if you guys followed the Cardi B trial, the civil case. Oh, chat. So it seems like from a quick glance, and maybe I'm not understanding something. Let me pull up a document or two here real quick since we have a few minutes. Let's see. The first thing I saw was this first notice of continuance of plaintiff's motion to tax costs. So somehow Emani Ellis is looking for Cardi B to cover some costs, even though Cardi B won the case. Anyway, there was supposed to be a hearing yesterday, the 22nd, and on the 20th, this was filed. And it says, to the Honorable Court and all parties and their attorneys of record, notice is hereby given that Plaintiff Emani Ellis's motion to tax costs previously scheduled on January 22nd, 2026 at 8:30 a.m. has been continued to March 26, 2026 at 8:30 a.m. in Department T of the above captioned Los Angeles Superior Court Alhambra Courthouse. Plaintiff's counsel, Ron A. Rosen Janfaza, Esquire, is set to begin a jury trial in another civil matter on January 20th, 2026 at 9 a.m. and has become unavailable on January 22nd, 2026 at 8:30 a.m. Therefore, the motion to tax costs has been continued to March 26, 2026 at 8:30 a.m. A voicemail message was left for defense counsel Peter Anderson Esquire on January 19th, 2026, confirming the continuance. A voicemail message was left confirming the continuance. So I'm like, what? Plaintiff's counsel is willing to continue the motion to tax costs should this date not work for defense counsel. So this conflicts. This is weird. You don't leave a voicemail confirming something with somebody you're not contacting, right? You don't make contact if you're leaving a voicemail. You're initiating the continuance. The other party might not be aware. And if you're leaving a voicemail, you have not had two-way stipulation. And then you're also saying, will also work if that doesn't work for defense, which means, again, you do not know if defense is agreeable. So Ron A. Rosen Janfaza signs this on January 19th. It's on the docket dated January 20th. There's that. And you could see that he paid for this booking to get a March 26th date for a hearing, which is 2 months away. So I'm like, what the heck? This isn't how this works. This isn't how this works. Anyway, so then the next filing, here we go. Now this is from Cardi B's team, and it was also January 20th, so I'm assuming as soon as they saw this come through, they're like, oh my gosh, here we go again. This is filed. We've got defendant's objection, so Cardi B's objection to plaintiff's unilaterally continued hearing date on motion to tax costs. Defendant Cardi B, professionally known as Cardi B Defendant, respectfully submits his objection to Plaintiff Emani Ellis's first notice of continuance to plaintiff's motion to tax costs, which plaintiff filed on January 19th, 2026. Plaintiff has unilaterally attempted to continue the hearing date on her motion to tax costs from January 22nd to March 26, 2026, a total of 63 days. Plaintiff's counsel, Mr. Ron Rosen Janfaza, claims he has become unavailable on January 22nd, 2026, because he is purportedly set to begin a jury trial in another civil matter on January 20th, 2026 at 9 a.m. And then we have some from the California Civil Courtroom Handbook, a quote, generally there is no right to a continuance as a matter of law of a hearing date on a notice motion. Instead, the court may continue a notice of hearing if the parties stipulate to the continuance, which is what you would typically see. The court shall postpone, this is the California Civil Procedure Code, the court shall postpone a hearing of any motion for a period not to exceed 30 days when all attorneys of record of parties who have appeared in the action agree in writing to such postponement. So there's like 3 things that we're not doing here from Ron's notice. And then we have, let's see, a cite here to Pham v. Wen that says, explaining that this code section is directory in nature, and courts retain discretion not to grant continuances. But plaintiff did not obtain defendant's stipulation to the requested 63-day continuance. Furthermore, plaintiff's purported excuse rings hollow. Plaintiff's unilateral notice is not accompanied by a declaration of counsel or other supporting evidence. And assuming Mr. Rosen Janfaza is scheduled to begin a trial on January 20th, 2026, he would likely have known of that trial date at the time he set the hearing on the motion. Also, Mr. Rosen Janfaza has repeatedly claimed trial conflicts to delay proceedings in this case, and at least once knowingly scheduled a trial to conflict with the trial in this case. More likely, Mr. Rosen Janfaza is claiming unavailability in the hope of getting another opportunity to file a reply, which he failed to file by the current January 14th, 2026 deadline. Finally, assuming Mr. Rosen Janfaza is in trial on January 22nd, 2026, that purported conflict can be addressed simply by requesting priority at the current hearing date. Mr. Rosen Janfaza's trial in no way justifies a 63-day continuance of the hearing on plaintiff's simple and baseless motion to tax costs. For the foregoing reasons, defendant respectfully requests that the court reject plaintiff's unilateral attempt to continue the hearing date, and that the court hear plaintiff's motion to tax costs on its originally noticed date of January 22nd at 8:30 a.m. Alternatively, if the court hears plaintiff's motion on March 26, 2026, defendant respectfully requests that the court not permit plaintiff to file any reply in support of her motion, as the reply deadline has already passed. And I don't see an order yet, like on the docket. I don't see any updates since this, but I'll keep looking. But that's where we are, you guys. I'm going to clip this out, so sorry about the banner still being about the trial that we're watching live as we're talking about this. But yeah, that's the Cardi B update for now. I'll keep looking at the docket.